It's funny. Sometimes your job can feel like a total mystery, right? One minute you're killing it, the next you're not quite sure where you stand. Well, what if I told you the secret to a solid, predictable job is actually hidden in plain sight? It's the employment contract. Think of it as the blueprint for your entire working relationship. And today we're going to show you how to read it, how to understand it, and how to make sure it's built to last. So picture this. You get an amazing job offer. You shake hands, you're all smiles, and you're ready to start Monday morning. That's all you really need, isn't it? A firm handshake and your word. That should be enough. But is it really that simple? Well, here's a surprise. That handshake deal? In the eyes of the law, it can be just as real as a 20-page document. Seriously, it's a binding contract. And it's not just about what you say either. It's what you do. Even the unspoken stuff, the things that are just understood through actions, can hold up in court. This is exactly why you need to know the rules of the game. Okay, so how are we going to build this rock-solid understanding of employment contracts? We're going to follow a simple blueprint. First, we'll lay the foundation and talk about why contracts matter so much. Then we'll put up the 4 essential pillars that every valid contract needs. After that, we'll take a look inside the blueprint at some common terms, compare 2 very different types of builds, that's employees versus contractors. And finally, we'll give you the key takeaways to build it right. All right, let's start at the beginning, the foundation. A good working relationship really does start with a good employment contract. It's the bedrock that everything else is built on. So what even is an employment contract really? Just think of it like a roadmap. It's an agreement that clearly lays out all the important stuff, the terms, the duties, the responsibilities for everyone involved. That way, there are no surprise detours down the road. And the whole point here is clarity. A good contract isn't just about protecting yourself legally. It's a communication tool. It makes sure everyone is on the exact same page from day one, which goes a long way in preventing misunderstandings and, building a relationship based on trust. So what's the secret sauce? What makes a contract legally legit? It's not magic, I promise. It really comes down to 4 essential elements. I want you to think of them as the 4 pillars holding up the whole structure. If even one of those is missing, the whole thing can come crashing down. Pillar number 1 is the offer. And this has to be a clear, straightforward proposal. It can't be wishy-washy. It needs to spell out the specific terms of the job. No room for confusion. Next up, pillar 2, acceptance. This is kind of like the I do moment of the contract world. The offer has to be accepted exactly as it was presented. If you change anything at all, you're not actually accepting it. You're starting a whole new conversation. Pillar number 3 is called consideration. It's a bit of a fancy legal term, but it just means both sides have to get something of value out of the deal. You bring your skills and your time, and in return, your employer brings the paycheck. Simple as that. It's the ultimate trade. And the final pillar, number 4, is legality. This one's pretty much common sense, right? The whole point of the contract has to be legal. For example, you can't create a legally binding contract to hire a hacker to break into your competitor's computer system. That's just not gonna fly. Let's see how these pillars work in the real world. Let's say Jeff offers Nathan a cleaning job for $15 an hour. Nathan says, sounds good, I'm in. Boom. We've got a clear offer, a simple acceptance, an exchange of value, work for many, and it's all perfectly legal. Just like that, you've got a valid contract. But what if Nathan comes back and says, how about 20 an hour? Now that's not an acceptance anymore. What he's just done is make a counter offer. He's essentially tossed the ball back into Jeff's court. Now it's up to Jeff to decide if he wants to accept the new terms. Okay, so we've got our 4 pillars standing strong. Now let's grab the blueprint and take a look inside. We're going to check out some of the most common terms and clauses you'll actually find in a written employment contract. So every contract is going to have the basics, right? Who's involved, what the job is, when it starts, how much you're paid. But, the devil's always in the details. You'll want to pay really close attention to things like the termination clause. That's your exit plan. And keep an eye out for any restrictive clauses, because those can sometimes follow you even after you've left the job. And here's something a lot of people don't realize. You might think your contract is set in stone, but not so fast. If you've been at your job for a while and your role has changed a lot, maybe you got a big promotion or your duties shifted, that original piece of paper you signed could be totally out of date. It could be obsolete. It's like trying to use a map from 1995 to navigate a city today. Let's talk about Dan from Tasty Pretzels. For 7 straight years, Dan's been signing a new 1-year contract every single year. But here's the interesting part. The law doesn't really care about the label on the contract. It looks at the pattern. And a pattern of renewing a contract over and over and over again starts to look a lot like a permanent, indefinite job. So if Tasty Pretzels decides to let him go, they could be on the hook for severance, just like a regular employee. Now, let's switch gears and talk about two very different ways to structure a job: being an employee versus being an independent contractor. And trust me, it's not just a title, it's a huge legal distinction that impacts everything: your rights, your taxes, everything. Just take a look at the breakdown here. The differences are pretty stark. Employees get a whole safety net of legal protections and benefits. Contractors, on the other hand, are their own boss. They have more freedom, but they also have a lot more responsibility. When it comes down to it, the biggest factor the law looks at is control. Who's really in charge of the work? And getting this classification right is a really big deal. It's not optional. If an employer tries to call someone a contractor just to get out of paying benefits and taxes, they're basically playing with fire. The legal penalties can be massive, and the back pay they might owe can be crippling. Okay, we've laid all the groundwork. We understand the theory. Now it's time to actually build this thing. Let's go over some practical tips you can use to construct a contract that's fair, strong, and built to last. Here are 4 golden rules for building a good contract. 1, keep the language crystal clear. No jargon. 2, make sure you're playing by the rules and meeting or even exceeding the minimum legal standards. 3, don't rush it. Give the other person plenty of time to read it and get advice. And 4, this is a big one. If you ever want to change the contract down the road, you have to sweeten the pot with something new, like a raise or a new benefit. And that brings us right to our final thought for today. Whether you're an employee or you're an employer, I want you to just take a second and really think about this question. Look at the job that's being done every single day, and then think about that contract that was signed. Do they still match up? Because at the end of the day, that blueprint is supposed to reflect the building, not the other way around.